Ladies and gentlemen, welcome to the National Constitution Center. I am Jeffrey Rosen, the president of this wonderful institution, and let's do it together, ladies and gentlemen, which is the only institution in America chartered by Congress to disseminate information about the US Constitution on a nonpartisan basis. Beautiful.
Impressive.
Isn't it? These are congregants at the Church of the Constitution, and we are here for learning. Amen. Tell it, brother. We are here to inspire ourselves tonight, and I'm here to thank you for showing up on this snowy evening to join me in celebrating the launch of my new book on William Howard Taft. Here's a snow anecdote that is relevant for this evening. On the morning of Taft's inauguration, he met with Theodore Roosevelt. And it was so snowy that they couldn't get through the streets. And Roosevelt said, "Well, Will, the storm will soon be over. As soon as I'm out, where I can do no further harm to the Constitution, it will cease." And Taft replied, "You're wrong, it's my storm. I always said it would be a cold day when I got to be president of the United States." And I go on to say that both predictions about the constitutional threats that Roosevelt would pose in his efforts to impose his program by executive orders and the political costs of Taft's efforts to correct them would prove to be correct. So we're here tonight to discuss Taft's legacy as our most judicial president and presidential chief justice. And I can't think of a better interlocutor and colleague and friend to talk about that legacy than Judge Douglas Ginsburg of the US Court of Appeals for the DC Circuit. Chief Judge Ginsburg is one of America's most distinguished jurists, professors of constitutional and administrative law, and students of William Howard Taft. And I sent him the manuscript of this book. He proved to be one of its closest and most astute readers, and he contributed what I think encapsulates Taft's legacy better than anyone else. Judge Ginsburg said, and I quote him in the book, that William Howard Taft is our most underappreciated constitutional figure since George Mason, who refused to sign the Constitution because it contained no Bill of Rights. So that's an extraordinary claim. I tried to support it in the book, so let's begin by thanking Judge Doug Ginsburg. And now I'm in the unaccustomed position of turning it over to you.
Thank you, Jeff, and all these letter carriers who came through the snow to be with us tonight. Well, I think the book has a fair chance of redressing the underappreciation that Taft has suffered. I commend it to you. I've read it now 2 times and gone through it again today on a more abbreviated basis, and I think it's a really first-rate treatment. Succinct, it's not ponderous. What is it, 200 pages, including the index, I think, and the extensive footnotes. But it really, I think, does a wonderful job of capturing and giving a portrayal of a whole person. A person who had one of the most extraordinary careers in the course of our history, really. Now, when I started reading the book, I didn't know a lot about Taft's personal life. Of course, we all know that he was lampooned for being our largest president. And I knew a little bit about his work in reform of the federal judiciary, which was very important and is with us still today, and we'll discuss that. But I didn't know, and I doubt that many people here know, that that he was not only elected to an Ohio lower court, but that he served as governor of the Philippines, Secretary of War, President, and Chief Justice, of course, and some other administrative posts as well. He was a brilliant administrator in a way that for which there are very few models. I mean, there are very few people that can, even since then, who can lay a claim like that to successful administration. So I'd like to let Jeff bring out a little bit for you first about the man, before we delve into his career. The career is fascinating, but I think we understand it better, as you will when you read the book, because you do first traverse his history and education and personality. So Jeff, why don't you tell us a little bit about his relationship with his father?
William Howard Taft revered his father, Alphonso Taft. Alphonso Taft was one of the founders of the Republican Party. He helped draft the Republican platform of 1857, which denounced the emerging conflict on slavery and committed the Republican Party to equality. And he absorbed from his father the idea that to be Chief Justice is better, as Alphonso Taft put it, than to be president, in my estimation. What a remarkable injunction to the son, which the son so absorbed that he pined to be Chief Justice and agreed to run for president with the greatest reluctance at the urging of his wife and Theodore Roosevelt. Taft and his father would read the Constitution together in Taft's father's library at the Taft Museum in Cincinnati, which I had the pleasure of visiting. And I, with the wonderful curator, Paula Morant, opened the bookcase and saw the inscribed copy of the Dred Scott decision where Alphonso had called out the dissent of Justice Curtis, signaling his disapproval of this notorious decision, which came out in 1857, soon after, right before Taft's birth. So he's absorbing from his father this love for the Constitution, a commitment to equality, and a commitment to excellence, but this is also creating in him great anxiety. The father is constantly exhorting him, mediocrity will not do for Will. And Taft has a habit of procrastinating. He writes all of his stuff at the last minute, as I do. I say in this book that I got the assignment years ago and procrastinated for years, and only when given a 6-month deadline did I produce the thing in 6 months in the spirit of William Howard Taft. So he, like his father, he goes to Yale. He's second in his class, which isn't good enough for the father. He agrees reluctantly to go into politics, and the experience repels him because he's appalled by the local corruption. And finally, he's elected and then appointed a judge, and he finds it a kind of heaven because his father has trained him to believe that being a judge is the greatest calling. The father was a judge in Ohio and was vilified for his principled opinion, declaring the importance of the separation of church and state, and repudiating a law which had prohibited the reading of the Catholic or Douay Bible. And Taft, the son, attributed his father's subsequent political problems to this principled decision, and he took from his father the idea that a devotion to principle is important above all. And then the final thing to say, I guess, about the relationship with the father is it may have played into his relationship with his weight. So we think about Taft as our largest president, and he was 340 pounds when he was president. But he was not large for most of his career. Basically, he had eaten his feelings as president because he hated being president. And after he stepped down as president, he lost 75 pounds in less than a year on a paleo diet involving lots of fruits and vegetables and gluten-free biscuits and beef bouillon. And for most of his life, he was quite trim as a result. And when he was large as president, he had obstructive sleep apnea. He couldn't sleep for more than a few minutes, and he would jar awake every few minutes. And as a result, he would fall asleep in public in meetings with the Chief Justice and at the opera and so forth. And he was unable to focus. When he lost the weight, he was incredibly focused and attentive. Today, we would have sympathy for him for essentially having a disability. But it's in his day, he was made fun of. There are cruel jokes about him, Taft in a bath and so forth, which we can talk about. But it's really a remarkable testament to the self-discipline that he inherited from his father, that he took the time to lose the weight. He would record his weight meticulously every day. And then in this amazing moment, he compares self-restraint in losing weight with self-restraint in a democracy. and says that citizens in a democracy have to restrain themselves from being guided by passion in the same way that individuals have to restrain themselves from eating too much. So it's a beautiful symmetry for the most constitutional of presidents, and all of it goes back to his relationship with his dad.
Fair to say, Jeff, that he never really could please his father?
No. On his father's deathbed, he looks at him and with the sweetest expression possible, Will remembered, he said, "Will, I love you beyond measure." And that was incredibly meaningful to him. But he felt always that the father's love was conditional. He felt a need to defend his father's honor. Once when a newspaper editor insulted the father, Taft walked over to the newspaper editor's office, pulled him up by his arms, and bashed his head repeatedly on the ground. Wow, indeed, showing a thin-skinned sensitivity to criticism at worst, or a devotion to family honor at best, that he repeated throughout his career. We can talk about his sunny temperament and his good humor against himself, but he was very averse to criticism, and this led him to lash out impetuously against critics later in his career with disastrous results when he fired some crucial subordinates, heedless of the political consequences, and that too may have gone back to his dad. But and the combination of his father's conditional approval and also his wife's conditional approval, that's a lot to deal with.
Nellie, I think, wanted him to be president before they even were married. That was her ambition for him.
Nellie Taft goes to the White House under President Harrison when she's a young woman, before she's out as a debutante, and she's so entranced by the glamour of Washington that she goes home in Ohio and tells friends, "Someday I will marry a man who will be president of the United States, so I can go back to the White House." And she was single-minded in this devotion. She marries Taft. He wants to stay on the bench. She's constantly pressing him to advance in his career and strategizing with him as he moves ahead. And she's also withholding approval from him. And he says sort of plaintively, "You're so cross with me. You know, I try to be good, but you're angry even though I know you love me all the same." She's deeply intelligent. They read Trollope together. They bond over their love of books when they're courting. And he's so devoted to Nellie that when she achieves her ambition and attains the White House and is just at the top of the world, just after several months in the White House, she has a tragic stroke when they're on the presidential yacht. And when Taft learns of her condition, he looks like a great wounded animal, according to his aide Archie Butt. He's so distressed about his beloved wife, and she's seriously disabled, and he tenderly nurses her back to health, teaching her how to speak again, saying, "There, just say that's better, darling, I know you can do it." Spending hours every day tending to her, and finally she recovers some of her speech. So it's incredibly poignant and tragic that she, who wanted so much to attain the White House, is unable to enjoy the fruits of this achievement, whereas he who spurned it is sort of burdened with the whole thing. But yes, they were devoted to each other, and when he dies, Taft's final words, he can barely speak, he also has a sort of stroke, and he's carried to the car from Union Station, and his biographer, Henry Pringle, says the occasional darling escaped his lips. He's kind of thinking of his wife. So they were very close, but she was a tough customer, always withholding approval, like his father, and perhaps that's what spurred him, against his instincts, to higher and higher achievements.
I think his closest friend, Theodore Roosevelt, has a similar relationship, trying to please TR.
He is. He, as you say, lionizes TR and idolizes him, and is such an effective administrator. You were right to note his administrative achievements, that TR considers him the indispensable aide and appoints him Secretary of War, and he's appointed by McKinley to be governor of the Philippines. And Roosevelt wants him back to be on the Supreme Court, and Taft so much wants a Supreme Court seat, but it's the only administrative task he's ever successful in, and he's so popular in the Philippines that when he threatens to leave, there's a popular demonstration with the Filipino people crying out, "Queremos Taft, we want Taft." They're marching in front of the presidential palace. They're so appreciative of him for creating an education system and writing a constitution that he reluctantly gives up the Supreme Court seat. And Roosevelt crossly says, all right, stay where you are. I understand I can't have you. But Roosevelt says, if only I could clone you, one could be on the court, and one could be Secretary of War, and another could be my chief administrator. And then there's this great moment in the White House where Roosevelt is there with Taft and Nellie, and he puts his hand on Taft's head and says, I am a seer, and I'm looking into the future, and I see a crown. Will it be the justiceship or the presidency? Make it the justiceship, says Taft. Make it the presidency, says Mrs. Taft, and Roosevelt continues. But Roosevelt picks him as his hand-picked successor because Taft is such a great number two man. He's so efficient. He has no ego. He carries out Roosevelt's wishes. Roosevelt is just pure act, as Henry Adams said of Roosevelt, and Taft creates the administrative apparatus in the Philippines, in Cuba, and building the Panama Canal that makes it possible for Roosevelt to achieve all of his ends. And then he becomes president, and Roosevelt has questions about him. Right after that quote I began by reading about the storm, Roosevelt goes home and tells a journalist friend, Taft, he'll do okay, but he's weak. He sort of suspected that Taft didn't have the instinct for popular leadership that he did. And then, of course, the relationship tatters over this unexpected series of events, leading to one of the most dramatic breaches of a friendship in all of American history.
There's something missing or mysterious, anyway, in this account, particularly about his declining twice the offer to go on the Supreme Court. The thing he wanted most in life comes to him at a fairly young age. And he declines twice. And you say, well, he was enjoying the popularity of being governor of the Philippines. But he says repeatedly, and you quote him later on, I would never want to play a popular part. I would never do anything to play a popular part. Unlike TR, who catered to the public and was able to motivate and rally the troops, Taft was not very good at that and didn't aspire to be good at that. And yet you attribute his twice declining the appointment to being popular in the Philippines?
You're right to press on that point, and that quotation that you call our attention to is central. I will not play a part for popularity, as you said. He told his aide Archie Butt, who faithfully served both Roosevelt and Taft and admired both men, and Archie Butt's memoirs of the Taft administration are the most intimate and sympathetic account of Taft. And that idea that the president should never seek popularity but derives his power from the Constitution rather than from popular approval became the essence of Taft's constitutional vision. So why didn't he accept the Supreme Court seat? I think you're right that maybe his Nellie's desire that he be president must have had something to do with it, and maybe he wasn't as entirely forswearing of ambition as the simple account suggests. He may have been torn. He had normal ambitions, and maybe he just decided to keep the option open by going along with her.
And he had young children then, too.
Sorry?
He had young children.
He did.
He and Nellie out in the Philippines, and he probably had more opportunity to be with his family there than he would have had in the Supreme Court role or any other back in Washington. But anyway, it's a contradiction in his life, not in your book. I mean, that's what he did.
Yeah.
But it seems contradictory on his part. I had my students in a seminar read this book and write comments on it. And one of them, looking at this pattern, said, well, was he so selfless in serving his father, his wife, his friend Roosevelt for so long? Or did he have a lack of conviction and let them fill the void?
What an interesting question. I think it was more of a judicial conception of himself and of his role. He preferred being a neutral arbiter, a conciliator, a administrator, a problem solver. That's why he was such an incredibly effective Chief Justice, one of the most effective chiefs since Marshall. Now there's a good psychobiography of Taft. It's a sort of dangerous genre, but Judith Anderson has a good one where she attributes much of his psychology to the conditional approval of his wife and of Roosevelt. And he was so conflict averse, despite the spasms of anger, that he preferred to see himself in the judicial role. He said, I love judges and I love courts. To me, they're my idea of heaven on earth. So maybe the desire to be the neutral arbiter rather than taking strong political stands coincided with his psychological needs to evolve to avoid conflict. And Archie Butt said, the president is so averse to conflict, he hates it of any kind, but once he takes a dislike to someone, he's a great hater. How to reconcile all that, I'm not sure, but maybe that added up to a lack of conviction.
And correspondingly, highly valued loyalty.
Very much so, yeah.
You bring that out very well throughout the book.
Yeah.
So when you say a judicial, not judicious, he was of course judicious, but a judicial president, would you say exactly what you mean by that?
I mean, it's just so exciting to read someone's work and have them tell you exactly what they're trying to achieve. There's no mystery about what Taft's vision of the presidency was, because he extensively wrote about it. There are 8 volumes of his speeches, which I've helpfully condensed down into a short 200 pages, but you can read them too. And he runs for president on a constitutional platform. He wants to put Theodore Roosevelt's activist executive orders on firm constitutional grounds. He agrees with Roosevelt's environmental effort to conserve lands for federal protection. And he agrees with Roosevelt's platform of bringing antitrust suits. But he disagrees with the idea that the president can achieve his domestic and foreign policy goals through executive order. Sound familiar? As a result, he says, the task of the next administration will be to perfect the machinery of government and to put the executive orders on firm constitutional grounds. And that's why his main promise in the campaign of 1908 is to persuade Congress to lower the protective tariff. At the time, the Republican Party is split over tariffs. There are revisionists led by progressives who want to lower them because they believe that the protective tariffs favor Eastern manufacturers over Western farmers and hurt consumers by raising prices for all. There are the stand-pat Republican conservatives in Congress, and the platform is kind of wishy-washy and says we commit to a revision of the tariff without specifying how much. This is so controversial that Roosevelt wimps out and refuses to engage the tariff battle because he knows it'll tear the party apart. But Taft, the principled constitutionalist conservative, says in his inaugural address, I'm going to call Congress into a special session immediately, and strictly construing his promise, he does exactly that. And he calls the special session, and the Congress people are all waiting for Taft's leadership, and the clerk of the Congress reads this 340-word message from the president, and it says the following: as I said in my inaugural address, I think Congress should lower the tariff. You can read what I said, please lower the tariff. And they're stunned, they can't believe that he just dashed it off that morning. But for him, the president under the Constitution has the power to recommend legislation, but no authority to interfere in congressional deliberation. So he believes that any kind of popular leadership would be a violation of the president's constitutional duties, and as a result, he sits back and the whole country goes haywire, and the final bill that's passed lowers some duties, but not satisfying no one, and Taft unwisely praises it as the best tariff bill that could have been passed, and he's vilified for that. And basically, it's a political disaster because Taft is being such a constitutionalist. He approaches every decision in constitutional terms asking, does the Constitution explicitly authorize this action? Unlike Roosevelt, who says that the president can do anything the Constitution doesn't forbid. And as a result, Taft issues all sorts of vetoes on constitutional grounds, including on his final days in office, vetoing a bill involving the interstate shipment of liquor under Prohibition because he thinks it violates Congress's power under the Commerce Clause. So there are constitutionalist conservatives today who think that Congress should have to specify the precise part of the Constitution that justifies its action, and now progressives are rediscovering the dangers of presidents who rule by executive orders rather than being authorized by the Constitution. For both sides, Taft should be a hero of what a principled constitutionalist judicial president looks like, because all of his actions are motivated by constitutional rather than political considerations.
Jeff, where did he get the idea? I don't see the chain of reasoning in Article 2, the president, the executive branch, that led him to conclude he could not lobby for his proposals.
After he leaves the presidency, he delivers a series of lectures at Yale, which are collected in the great book, Our Chief Magistrate and His Powers. And the fact that he calls the president a chief magistrate is a sign of the limited role which he gets from James Madison, which views the presidency as a ministerial office responsible for carrying out the will of the majority of Congress, which was the Whig view that prevailed at least until Andrew Jackson, and then was totally transformed by Roosevelt and Wilson. So our chief magistrate in his powers, he just reads the Constitution and says Congress has the power to make the laws and the president to take care that they're faithfully executed. And I think he's just being a strict constructionist as well as drawing on this old Whig tradition.
So self-effacing, contrary to self-interest, may be in any event politically very damaging, or limiting, I should say, what he could accomplish because of that.
Tremendously so. He could have done a little bit more lobbying on behalf of the tariff bill and draw some lines in the sand. Instead, by being totally passive, he allowed the bill to satisfy no one. His compulsive truth-telling is also really politically damaging. That phrase about the best tariff bill the Republican Party ever passed was strictly true, but incredibly unwise. I called it a Kinsley gaffe after the great journalist Michael Kinsley, who said, in Washington, a gaffe is when a politician tells the truth. And Taft had this sort of compulsive truth-telling that got him into trouble. But his biggest political, it's true, it's true names.
Political Asperger's.
Political Asperger's, absolutely. We could use more of that. But his biggest political problems are self-inflicted, of course, and they involve his fatal decision to fire one of Roosevelt's closest aides with disastrous political results.
There's a nice bit in the book, several pages, maybe it's a chapter, devoted to antitrust, my other interest, other than the Constitution, that is, and my other teaching portfolio. So we think of Theodore Roosevelt as being the aggressive president who gave content or vigor to the antitrust laws in a way that hadn't happened before. Come to find out in this book that this was a point of falling out between Roosevelt, TR, and Taft. Although they were both strong adherents to the antitrust program, it was Taft who brought more cases. Why did they fall out on such common ground?
I'll answer, and then I'm going to ask you whose position you found was more persuasive. But as you say, Taft brought more antitrust suits in one term than Roosevelt brought in nearly two. And that's because they had diametrically opposed visions of antitrust. For Roosevelt, the Hamiltonian wanted to create a federal agency, the Bureau of Corporations, to oversee the big banks. Taft, the Madisonian constitutionalist, wants strong law enforcement to enforce the antitrust laws. And in the election of 1912, Wilson, the Brandeisian or Jeffersonian Democrat, wants to break up the big banks so that they can then be taxed by the states. So Taft just believes so passionately in law enforcement in a principled way that he brings suits that Roosevelt wouldn't bring, including, fatally for his relationship with Roosevelt, a suit against Standard Oil, which Roosevelt had blessed as president, and Roosevelt believed that Taft had tacitly endorsed too, but by bringing the suit, Taft embarrassed Roosevelt deeply because it suggests that Roosevelt had been duped by blessing a merger to placate J.P. Morgan, who he thought was saving the country during the crash of 1907. And Roosevelt's sister, Mamie Roosevelt, said Roosevelt never forgave Taft for bringing the suit, but Taft believed that the law required it, and that's why he did it. And that, combined with a few other firings, severed their relationship. So Judge Ginsburg is one of the most distinguished antitrust experts in America. You taught antitrust at Harvard Law School, and you've had many important cases about it. Whose view of antitrust was more persuasive?
Well, I think, frankly, I would side with Taft here. The regulatory approach is ultimately expressed in the creation in 1914 of the Federal Trade Commission, more or less along the lines that you just described for the proposed Bureau of Corporations. And if you see the building outside the FTC in Washington, there is someone, strong figure, this is a big sculpture in concrete, restraining what would seem to be a wild horse, which is business, or maybe it's a pair of horses. It's quite dramatic. So anyway, the litigative approach strikes me as having been much more productive over the years. The FTC has from time to time taken a more regulatory approach. That's out of favor again now because of a lot of untoward consequences when a government agency becomes a regulator without a specific mandate from the Congress as to how to regulate it, what exactly to do. When I was at the Justice Department running the Antitrust Division, we were administering the decree involving the breakup of AT&T, and we had the Judge Green would get a petition from one of the broken up companies that they wanted to go into some new business. He would ask the department. We had a whole staff of people evaluating whether it would be anti-competitive for them to. We were a little FCC, FTC all together, and it was a totally inappropriate role for a law enforcement agency. So we managed to shed that, but enough about that. But here are these two figures, both devoted to this principle, and then falling out over how the means by which to do it. And Taft, as you report, thought that the key was whether conduct undertaken by a company was done with malicious intent. We might say anti-competitive intent today, whereas Roosevelt would have said, just big is fine, just regulate them. Right? Okay. You talk about in the book his judicial approach to foreign policy, a place where it might seem the least obvious. So you're going to share a little bit about that?
This is so great. So first of all, Taft, he believes in what some called dollar diplomacy, and what he believed was just free trade and promoting economic cooperation. So he persuades Congress to pass the first Canadian free trade agreement. And Canadian voters tragically reject it because Taft commits another Kinsley gaffe. He writes to Theodore Roosevelt, boy, it's great that Congress passed this. If the Canadian voters ratify this, Canada is going to be economically a mere annex to the United States. And this leaks out, and in a kind of Brexit-like explosion of populism, the Canadian voters reject tricky Taft and they don't pass the treaty. But then there's all of this clamor for war with Mexico. Again, sound familiar? And the people are pressing Taft to send troops across the border because they're amassed on the border in order to protect against the spillover effects of the Mexican insurrection. But Taft reads the Constitution and he says Congress has the power to declare war, the president doesn't, and the president can't send troops over the border without a provocation. His precedent for this is the dispute when James Knox Polk sent troops over the border before the Civil War, and a young congressman called Abraham Lincoln demands that Polk identify the precise spot where Mexican troops have crossed the border in order to justify the constitutional action, earning Lincoln the nickname Spotty Lincoln. So Taft recalls the Polk example and doesn't want to repeat it, and therefore, despite the popular clamor for him to send troops, he doesn't, and as a result, the peace is kept, although he suffers political capital for it. Taft, surprisingly to me, becomes one of the great champions of not only international adjudication and the web of international arbitration that is now represented by the World Trade Organization and the Paris Peace Treaty and many of the agreements that the United States is thinking of withdrawing from, but also of a world court. And Taft believes that adjudication of international disputes, even on matters of national honor, that is, matters involving policy, should be ultimately subject to the rule of law. In that sense, he's the precursor of the failed League of Nations, which he supports despite his dislike of Wilson. And his vision of international arbitration created a kind of free trade consensus which has prevailed until pretty recently. So his legalized foreign policy is another example of his constitutional approach to this.
Was that a bit of naivete on his part?
Well, it certainly seems to have been in the case of the League of Nations, which didn't.
Well, and the idea of a world court.
Yes, indeed. And surprisingly, for such a devotee of liberty, because of course, as Chief Justice and as President, he believed that the purpose of the government was to interfere as little as possible with productive occupations of the people in order to promote liberty and the public order, and the hope for a world court seemed to go against that.
In discussing the 1912 campaign, I thought it was quite interesting. You described Wilson as Jeffersonian, Roosevelt as Hamiltonian, and Taft as Madisonian. We'd all like to be described as like any one of them, but here they are at each other's throats, and you've put this into a philosophical context. Can you elaborate a little bit?
Sure. Well, I have to put in a plug now for the great new exhibit that the Constitution Center is going to open on Thursday, Hamilton versus Madison, Jefferson, Adams, and Burr, the constitutional clashes that shaped America. There's the most incredible artifacts downstairs. I just saw them this morning, including Hamilton's writing desk and replicas of the dueling pistols, and the letter where Jefferson talks about the need to break up the Hamiltonian system. But this great exhibit shows the conflict between these three philosophies of government. And we know about Hamilton favoring large, energetic government, a sort of monarchical presidency, and a very broad congressional power. Jefferson, the devotee of states' rights and liberty, questioning the powers of Congress and the judiciary. But Taft is indeed a Madisonian, and this is what's so exciting to read about his constitutional writings. He says repeatedly, we are not a direct democracy, nor did the great framers of the Constitution intend that we should be one. They intended to create a system of slow and thoughtful deliberation over time, where the momentary passions of the people are restrained so that reason rather than passion can prevail. I'm paraphrasing, but he's directly channeling Madison in Federalist 10 and in the Federalist 55, and this notion that the whole American system will collapse unless thoughtful majorities can promote public reason, and that the role of the presidency is to promote public reason and to save the people from their own momentary passions, is preeminently Madisonian and really inspiring to see Taft embrace.
Madison right here.
I saw them. It's so impressive. Show the audience your wonderful Madison cufflinks, and I want
a profile
too. I would love to have those, or maybe Taft cufflinks. So
yeah, well, that's a good idea. I think that'll be a big seller.
That would be a huge
maybe
seller
after this book. Yeah.
It's gonna. So my friend Garrett Epps just wrote to me today about the book. He said the book is going to be huge. It's going to be a Taft revival, and he's going to be known as the notorious B.I.G. So I think it's going to be a pop cultural meme. There's just no question about it.
By the way, you mentioned that Taft, when he left the presidency, went to Yale to teach. I was very amused by his response to the offer of a chair in law. What did he say?
He said, I don't know about a chair, but if they've got a sofa, that would probably work. He had a bunch of jokes. He was so good-humored about the jokes, and he told a lot of jokes on himself and in our chief magistrate and his powers. He tells the story about the woman who came to see him when he was Secretary of War and asked that her son be admitted to West Point despite the son's physical disabilities. And Taft says, okay, the boy can come in. And the woman is so grateful that she exclaims, Mr. Secretary, you are not nearly so fat as they say you are. And then there's the story of Taft on the horseback, and he's boasting, or not boasting, but telling Secretary Stimson about the long ride that he had, and Stimson cables back, how is the horse? But it's funny and we laugh, but I have to say, I felt empathy for Taft because the jokes were really mean. I mean, the obsession about Taft and bathtubs, first of all, is completely made up. He was not stuck in a bath. That was a myth that was peddled by Ike Hoover, the White House usher, and was corroborated by no other sources. Although Taft did overflow a bath in 1915, and the water drips down on the guests below, and the New York Times reports that the next day he looks out at the ocean and says, someday I'll fence that in and get a piece of it so that I don't have to overflow baths anymore. And then there are these citizens of Colorado who are so obsessed with the idea of Taft in the baths that they offer him a specially constructed bathing costume that they want him to put on so that they can see the president displaying himself in their hot springs. But it was a different time, and it was considered acceptable to make fun of people in a way that we would consider today waitist. And he put up with it all with, good humor, but it must have been extremely painful, and it's good that we now live in an age where that sort of thing is not tolerated.
While he's president, he has the opportunity to appoint a new Chief Justice. And he does not elevate Charles Evans Hughes. He elevates Justice White, not Byron White, a predecessor. Cynical,
Absolutely.
manipulative, strategic.
So strategic. It's such an amazing story. As you say, he's got to appoint a Chief Justice. And he says when he signs the commission, it's an irony that I, who yearn so much to be chief, should be signing the commission of one who will take my place. He was very transparent about his thoughts. He's about to appoint Charles Evans Hughes, but Hughes is a young dynamo who, governor of New York, will go on to run for president, and alarmingly will probably outlive Taft. So Taft calls Hughes from the White House when Hughes is on his way dressing for the interview and calls off the interview. And instead, he appoints Edward Douglas White, a 65-year-old Southern Democrat whose only qualification for this bewildering appointment is that he's likely to die in time for Taft to take his place. So he appoints White Chief Justice, and White serves for about 10 years, and Taft goes on, but White refuses to expire. And Taft is constantly checking in on him. He'll stop by in Washington. How are you doing? How are you feeling? Would you like a little more cheese? And White just perseveres and shows no signs of retiring, and to Taft's distress. Happily for Taft, White unexpectedly drops dead of a heart attack right at the moment when Taft is beginning to despair. And then President Harding has to appoint a replacement. And then there's this, tense moment when Harding is dithering and he's thinking of appointing someone else. And thankfully for Taft, he's enjoying a bipartisan revival of popularity, both because Wilsonian internationalists like his support of international courts, and his role during the war revives his pro-labor credentials and effaces his reputation as the father of injunctions. So he's nominated by Harding and confirmed by an overwhelming majority. And what an amazing fulfillment of this lifelong dream, ever since his father, when he was in his youth, had told him that to be Chief Justice is greater to be president, to achieve his ambition, having set it up rather strategically. And Taft says, this brings me back from the position that I had been placed in 1912. And then he just flourishes to find your dream job. He just does it so well and with such energy and vigor. And he becomes the greatest Chief Justice since John Marshall in establishing the federal judiciary as a fully efficient third branch of government, in constructing the Temple of Justice, the beautiful Supreme Court building that today is a monument to Taft's vision. And Chief Justice Hughes said when he dedicated it, we are here today because of Chief Justice Taft's intelligence, persistence, and in passing the Judiciary Act of 1925, which, as Judge Ginsburg has written and spoken, gave the court control over its own docket and allowed it to focus on constitutional cases rather than distracting its energies, and shored it up as a fully equal third branch of government. And then Taft promotes unanimity on the court. He persuades his brethren to suppress their dissenting opinion. He promotes more consensus since John Marshall. He's so good that Louis Brandeis, who had been his great rival and in fact had unmasked him during congressional hearings during his presidency, and whose nomination Taft had opposed, says to Felix Frankfurter, Felix, how is it possible that we thought Taft was so bad as president, but he seems to be so great as Chief Justice? And Frankfurter's response is, he hated being president, and to be chief is all happiness for him. And that was partly true, but it also failed to understate the degree to which Taft's vision of the courts as a fully equal branch of government and his administrative skills and his temperament were so well suited to the role. So it's a beautiful second act. Not just beautiful, but really inspiring. And what an extraordinary distinction to serve as president and Chief Justice, to be, by all accounts, an average president. I mean, I think he deserves great respect as our most judicial president and as a model for a constrained presidency in an imperial age, but is an excellent chief. And let me ask you this, Judge Ginsburg. The 1993 survey I quoted puts him after Marshall, Hughes, Warren, Stone. I would rank him higher. Where would you put him as chief?
Would.
Maybe second or so, or something.
Second, probably.
Yeah. Wow. Isn't that great?
To Marshall.
Second after Marshall.
who is known today still as the great Chief Justice.
Yeah. Why would you say he's such a great chief?
Well, because I live in the world he created. The federal judiciary today is the judiciary that Taft gave us, or that he extracted from the Congress, in the sense that it's governed by a body called the Judicial Conference, which is the chief judges of each of the 13 circuits. When I was chief judge, was a member of that, and 13 more from the district courts, the trial courts. He, of course, created the building, which is symbolically important, but he also got legislation from the Congress that eliminated much of the appellate jurisdiction of the court, that is to say the mandatory jurisdiction, where someone has an appeal of right from a court of appeals or a three-judge district court to go directly to the Supreme Court. Now, there are very few exceptions that still have that model. Basically, it's all discretionary. The four justices of the Supreme Court can decide that they will grant hearing and take a case to be heard by the Supreme Court. That has transformed the court because it inevitably makes the court into a policy-making body, legal policy. So it's an example I mentioned here. When Chief Justice Warren and his colleagues decide to or embark on constitutionalizing criminal procedure, they're able to do it by their selection of cases. And to repeat that anecdote, Justice Brennan never delegated to his clerks looking through the thousands of cert petitions for review. He looked at them all himself, and when he was asked, doesn't that take a great deal of time? He said, not when you know what you're looking for. Now, so he really did elevate the court to a much different role in society, the federal judiciary.
In ways that he would have appreciated and not entirely anticipated. And as you suggest, the Judiciary Act, by focusing on the more contested cases, reduced the unanimity rate. So during the first part of Taft's chief justiceship, the court is converging around narrow unanimous opinions in the style of Taft's hero, Chief Justice Marshall. But after the Judiciary Act, things begin to fracture and there are more dissents and less unanimity. Our current Chief Justice Roberts also has praised Chief Justice Taft as well as Chief Justice Marshall, of course. I think admires both of them greatly. But it's much harder for a chief today to achieve unanimity, thanks partly to the reforms that Taft put in motion.
Now, one of the anomalies that you describe, I'm not sure you analyzed in the book, is Taft's willingness as Chief Justice to lobby the Congress hard and repeatedly, whereas president, he wouldn't do so for his own legislative program. What happened?
He really cared about building the building and getting money to build the judicial conference, and he was passionate about it. I guess he felt that his role wasn't constrained in the way that it was as president. But let me ask you, because you'd have a better sense, was that appropriate for him to lobby the Congress that way?
I think it was. Maybe it's just that it's been the norm ever since. There hasn't been a lot to lobby for. There was a long time when the judges were lobbying for a pay increase because they hadn't had one in 18 years or something. And the two justices, lately it's been for years now, Justices Kennedy and Breyer, go to the hearing for the annual budget or biannual budget, I guess it's annual, in the Congress and make the case presenting the budget for the entire judiciary. That seems to me entirely appropriate, and they're subject to questioning about that administrative matter, of course, nothing else. So, I mean, in a way, it's easy to see it as opportunistic, right? I mean, he looks into Article 2 and says, I can't interfere with the Congress, I can't try to alter their deliberations. And in Article 3 now, he's head of the judiciary and looks into Article 3, which is very brief, and decides he can do it.
Yes, but at least the theoretical justification for it would be the Madisonian one, namely his vision of the president deriving power from the Constitution and not from the people constrains the president to engage in popular leadership because the fear is that will make the president a demagogue who will encourage mob rule. And if the president's role is to encourage thoughtful deliberations, then the president should do exactly what Taft did, which is to issue speeches like judicial opinions. And Taft's speeches are incredibly detailed and long, and he will give budget numbers and figures explaining thoughtfully his positions for any citizen who wants to read them. His aide, Archie Butt, said that he delivered them relatively well and feared that they wouldn't read as well as they did when they were delivered on the stump, because Taft had a way of putting them over. Whereas when he's chief, he thinks his role is to build up the administrative structure of a judiciary strong and independent enough to check popular passions, to defend liberty and property rights while broadly deferring to Congress. And in that sense, it's a structural Madisonian ambition. So in that sense, there's a beautiful symmetry to his constitutional focus as presidency and chief justice. And the other incredible thing is, as president, on the campaign trail, he says the greatest need facing America today is the reform of civil and criminal procedure. Can you imagine a president in the State of the Union address saying something similarly today? And then as chief, he supports and lobbies for the very reforms that he had promised as president. So he believes that the efficient administration of the machinery of justice is itself an urgent national need. He wasn't able to achieve it as president, but he is as chief, and then he administers it in precisely the way that he promised.
I think that's an excellent account. And in particular, although it was not your principal point, the independence point, right? I mean, throughout his whole career, the independence of the judiciary is of primary importance. And the things that we just described, what he accomplished for the judiciary, bolstered its independence.
Dating back to his father, that separation of church and state dissent convinced Taft that to resist popular passions is the sign of being a principled judge. He never succumbed to criticisms of him as being pro-labor or the father of injunctions. He thought he was ensuring that labor and capital could compete on equal terms. And he will follow the law regardless of where it leads, and he's incredibly transparent about his reasons, and that's why he's such a model of a principled judge. There's one exception that I guess we just have to signal. The biggest scandal of his presidency was when he fired one of Roosevelt's main environmental aides, and it was a complicated story, but it had to do with a whistleblower who was claiming that the Taft administration was giving away federal lands to developers because of a conflict of interest in the Justice Department. And Taft is really angry at the whistleblower and fires him, and then he's angry at the superior, Gifford Pinchot, and fires him in a fit of pique. And no one disputes that he has the power to fire Pinchot, but Taft, in a fatal move that Louis Brandeis later exposes, backdates the memo that Taft reviews to justify his firing. And Brandeis exposes this, and it looks like the cover-up is worse than the crime. Now, Taft explains that he was acting just like a judge rather than a politician, and he hadn't had time to summarize all of his findings and just backdated the memo to accurately show the sequence of evidence on which he'd relied in releasing what was essentially, he viewed as a judicial opinion, and the explanation satisfied Congress, and he wasn't guilty of any underlying wrongdoing. But it was the only hint of scandal in an otherwise unblemished career devoted to the rule of law, and that's a pretty impressive track record.
His dislike of dissents that you've mentioned, and which Chief Justice Marshall had pioneered, is not something, I mean, I understand it as something that any Chief Justice would like to have. And I suspect that if we looked closely, every new Chief Justice has a statement to that effect. But there's a role for dissents. Is there not a function that's important or can be important and that is too easily suppressed?
Jefferson certainly thought so. He accused Marshall of creating a dissembling crew of sappers and miners and allowing Federalist sympathizers cringingly to hide behind the cloak of unanimity and concealing their true feelings. And justices like John Paul Stevens have felt that you have an obligation to dissent. And of course, you've written some great majority opinions and some great dissents. So there certainly is a role. And Taft wrote some great dissents, including, surprisingly, a dissent from the court's decision to strike down maximum hour laws passed by Congress on the grounds that, as Taft said, the evils of the sweating system require some sort of federal action. So Taft was willing to dissent when he thought it was necessary, but broadly his conception of the judiciary was like Marshall's, where the chief should speak for a united court because that was necessary to defend liberty and the Constitution. And he issues remarkably few dissents, especially in constitutional cases, like Marshall, who dissented only once in a constitutional case. And I think it's fair to say that the reason Marshall and Taft are considered, as you suggest, perhaps our best chiefs, is because they were such effective leaders of the court. They were able to mask the court, as Taft put it, to persuade their colleagues to suppress dissent. Taft persuaded even Louis Brandeis to suppress some of his dissents in the interest of promoting the institutional legitimacy of the court as a whole. And at times when the political branches are polarized and people see Congress and the presidency as being at loggerheads with each other, it's especially important, Taft believed, for the court to be perceived as a nonpartisan institution that unites justices of different perspectives around the rule of law, and that's why he was such a good chief.
And of course, the value of unanimity was probably greatest in the Brown versus Board decision, in which Justice Warren convinced two of his colleagues who were very beyond skeptical, who really did dissent, would have dissented, to hold their fire for the reason you just gave.
That's the greatest story of the suppression of dissent in the 20th century. As you suggest, Taft persuaded not only Robert Jackson, who's on the fence, but Stanley Reed, the great segregationist, to join a unanimous Brown decision. When Warren reads the unanimous decision to a spellbound courtroom, Thurgood Marshall looks up at Stanley Reed. He can't believe it. You too, Justice Reed, you joined this opinion? Reed nods down silently in respect. Yes, I joined it too. Electric moment. And that really, I think it's not a stretch to say Brown is in some way a tribute to the court that Taft created, the strong, independent court, confident enough to check the states on the most contested issue of the time, was made possible by the model that Taft set.
Another important case, Myers versus the United States. The president had fired a postmaster who sued for back pay, I believe. And the court, through Chief Justice Taft, upheld the president's decision, overturning an act of Congress that purported to preclude that, as I recall the case. Is that right?
It did indeed, and the act that Taft overturned precipitated the impeachment of Andrew Johnson. Johnson was impeached for violating the Tenure of Office Act, which tried to constrain the president from firing subordinates, including the Secretary of War, without congressional consent. Johnson did it anyway. He was impeached and narrowly acquitted. And Taft, in this opinion, says the judgment of history has been that the Tenure of Office Act unconstitutionally restricted the president's power to fire his subordinates, establishing the principle of a unitary executive who has broad discretion over the officers he appoints. Taft's decision was questioned during the New Deal by Justice Brandeis, who said that Congress does have the power to set up quasi-independent agencies like the Federal Trade Commission that can't be fired. And during the Reagan administration, the court upheld Congress's power to create independent prosecutors who can't be fired. This issue may soon be back before the Supreme Court, but Taft has become a hero for devotees of the unitary executive, both liberal and conservative, who believe in a strong presidency with control over the executive branch.
Of course, the tenure authorization for appointment of independent counsels expired, and the Congress, in light of the experience, chose not to renew. I don't think there was any sentiment, really, to renew it.
None at all. Democrats had enough of it during the Clinton years, although they're some perhaps changing their tune. I won't ask you to opine about an issue that may come before you, but there is a bill pending in Congress, co-sponsored by Senator Coons and others, that would restrain the president from firing the special prosecutor, and its constitutionality might come before the court, and if it does, Taft-Myers' opinion would be relevant once again.
President Lincoln spent a long night in the White House convincing Republican senators not to pass a law that would give a tenure of office to his war cabinet. This has been an issue in every administration from Washington through Bush 41. That's where the book ends, not your book, a book on the unitary president. Now, in describing this case, Myers against the United States, which of course upholds presidential power, you describe the opinion as one based on, quote, the text and the original understanding, close quote, of the Constitution. So would you say now we have in Taft an originalist?
He was not an originalist. He does say elsewhere that he doesn't say living, breathing, but he talks about the Constitution being attentive to practical considerations. And in that sense, he seems like more of a Hamiltonian in a willingness to take account of what he called the needs of modern government. And yet Myers is an originalist opinion, as was his decision in the Olmstead case, which held that wiretapping is perfectly constitutional because the government had put the wiretaps underneath a public sidewalk and didn't commit physical trespass when they eavesdropped on the conversation of a suspected bootlegger. Ladies and gentlemen, the greatest modern decision repudiating Taft's vision in Olmstead is Judge Ginsburg's decision in the Jones GPS case. This is the brilliant DC Circuit decision that held that the government's not allowed to put a GPS device on the bottom of someone's car and track their movements 24/7 for a month because Judge Ginsburg said, repudiating Taft, 24/7 surveillance can reveal so much about us, our thoughts, our movements, our intimate hopes and fears, that we do have an expectation of privacy in the whole of our movements. So in that decision, I don't know whether you'd call yourself an originalist or not, but you were translating the original understanding of the Constitution in light of new technologies in a way that Taft did not do in the Olmstead case. So in that sense, maybe you and he are mix Hamiltonianism with originalism.
Well, I would call myself an originalist,
Yeah.
but others would also as an epithet.
Well,
okay.
would you call yourself a Taftian?
Now that I've read the book, I would come closer
Wow.
to saying that. But I'm not sure that I would have lived up to his self-discipline, intellectual self-discipline in
Yes.
the offices that he held.
Yes.
You close the book with a very eloquent several pages, a coda that reflects on Taft's story in a contemporary setting. Several of the things you've said tonight clearly resonate with our immediate environment. Some people recognize that as you went. And you say that limited government, democratic deliberation, checks and balances, the rule of law, vigorous but restrained, but constrained presidency courts and Congress, all vigorous but constrained by the Constitution, have an increasing appeal in the current environment. And you say that's true of conservatives, of libertarians, of progressives. What's the evidence for that?
Look at this wonderful crowd here at the National Constitution Center, coming hungrily to educate themselves about civil dialogue and constitutional discourse. And I think because they're saying so, that my friends on the progressive side are criticizing the current president in precisely the same terms that my friends on the conservative and libertarian side criticized President Obama, namely that a president who rules by executive order is heedless of constitutional constraints and makes direct appeals to the people in order to circumvent the Constitution poses a danger to our constitutional order. Any citizen who lives online and reads the blogs and watches television knows that public discourse is not living up to the Madisonian ideals of thoughtful deliberation and public reason. And when one reads Taft about the necessity of promoting reason over passion and slowing down deliberation, all of us know in our hearts that we need to discipline ourselves in the same way that Taft disciplined himself to read more and to speak less and to be capable of the high enterprise of citizenship. It's a very high ideal, which is one reason that he failed entirely to be a popular leader as president. But it is inspiring to have a nonpartisan model of a constitutionalist president. And as we look for solutions in these anxious times for the speed and passion of public deliberation, I think all sides can find Taft as a model.
I told you it was an eloquent closing to the book. And now to the hour. Last question, if I may.
Please.
Your previous book was on Justice Brandeis. Now on Taft. It comes out somewhere in the book that there was a connection through Wilson. All right, you want to explain that briefly, the economic advisor role?
Brandeis was Wilson's closest economic advisor in the campaign of 1912. He articulated the vision of antitrust and of breaking up the big banks that Taft repudiated, taking the more Madisonian approach. And they also clashed in these congressional hearings where Brandeis embarrassed Taft and infuriated him. And then Taft opposes Brandeis in his confirmation hearings as an emotionalist, sort of not openly anti-Semitic terms. I was going to use the word globalist, but it's not quite that. But it's he's really angry at Brandeis for his conduct in the Pinochet hearings. But what's beautiful about this story is that they do make up on the court, and Brandeis praises Taft as a chief, and Taft says, Justice Brandeis and I are getting along famously. It's all happiness now on the court. It's just a sign of their maturity, their willingness to bury the hatchet, but most importantly, their shared devotion to the Constitution. They had very different constitutional approaches. If Taft was in the majority in the Olmstead case in holding that there was no violation of the Fourth Amendment, Brandeis writes the most visionary decision about privacy in the 20th century in his Olmstead dissent, and anticipating Judge Ginsburg, insists on translating the Constitution in light of changed technologies. But they were so devoted to the legitimacy of the court that Brandeis suppressed dissents for Taft, and Taft also joined some of Brandeis's decision. What a remarkable story in these polarized times of two fierce rivals. These were bitter rivals who at different times tried to destroy each other's careers, who buried the hatchet and converged because of their shared devotion to the Supreme Court and the Constitution.
So was it your work on the Brandeis book that brought Taft to your attention to the level of wanting to write a book about him?
No, I only write books through homework assignments. So, so basically, I was assigned to write about Brandeis through the Yale Jewish Live series, and was assigned soon after that to write about Taft by the American President series. This is this wonderful series, originally edited by Arthur Schlesinger and now by Sean Wilentz. But embarrassingly, this is almost the last book in the American President series. Only Presidents Obama and Trump are left. And that's because I just twiddled my thumbs and procrastinated so shamelessly for all these years because I was doing other things. But I do think that I was channeling Taft when I got this scary 6-month deadline that I imposed on myself. And it was such a pleasure to write it. I really felt the honor of trying to channel him and his thoughts to try to convey to you all that he has to teach about what being a judicial president and presidential chief justice is like. So it came out very quickly. It was more fun and meaningful to write than any book I've ever wrote. And it's this short, intense case for the relevance and constitutional legacy of William Howard Taft.
Some of the audience have questions, which I'll collect, I guess. Why don't you tell us, while I'm doing that, what's the next book?
I have an idea, but I don't want to jinx myself by revealing it. So I'll let, we'll just take, thank you so much for
all right, so you're keeping
collecting the cards.
You're keeping your
I think
options
so.
open.
You shouldn't, because as you say, maybe someone will assign me something else, and I'll
I will.
I'll be happy to take a homework assignment.
I'll think long and hard about it.
That would be
Thank
great.
you. More questions coming. Okay, thank you. Oh, someone is collecting more? Okay, I don't know. Okay. Okay. All right. Mrs. G. Baker from Iowa City writes, no. All right. Interesting. Did President Taft ever express any opinions on Lincoln's presidency? and how he went about freeing the slaves? And did Taft recognize our nation's racist heritage?
Taft was a devotee of equality, an African-American colleague of Alphonso Taft, to whom Alphonso left his law library, inscribed something to Judge Taft, the only man of his time who actually believed in the equality of African Americans. And Taft was committed to that principle. He supported African Americans who were on strike, and he did not share the racial prejudice of Woodrow Wilson, for example, who has a shameful legacy. But Taft on Lincoln Taft was devoted to Lincoln as our most constitutional president. And he was so impressed that Lincoln always insisted on constitutional justification, even for his extra constitutional actions. Taft notes in Our Chief Magistrate and His Powers that although Lincoln suspended the writ of habeas corpus, which Congress gives the power to do, because of the exigency of wartime, Lincoln insisted on going back to Congress once the emergency had passed and convincing Congress to endorse his suspension. So Taft gave that as an example of how Lincoln always acted within the Constitution as much as exigency allowed, and I think he was inspired by Lincoln's constitutional example.
Here's a question from somebody that I strongly suspect is a bachelor. So if he hated the presidency so much, why did he run in 1912?
I got it. Thank you. I'm being slow. Okay, that would be one reason, I suppose. But that wasn't why, though. It wasn't Nellie. It was his devotion to the Constitution. He was appalled that Roosevelt had become a demagogue who was supporting judicial recall and popular initiative and the recall of judicial decisions by popular vote. We have in the National Constitution Center, in the lobby, as you go out, look for it, this inspiring quotation from Theodore Roosevelt: "The people themselves must be the ultimate judge of the Constitution," 1912. It's crazy that this is in the lobby of the National Constitution Center, because this is from one of those speeches by Roosevelt where he's saying the people themselves have to be able to overturn judicial decisions by popular votes. And it was that persuaded Taft that Roosevelt had become a threat to the Constitution, and he ran to defend the Constitution. And he puts in the Republican platform the need to resist judicial recall and initiative. He vetoes the state constitutions of Mexico, of Arizona and New Mexico, because they contain provisions for judicial recall. So even though he hates being president and he wants to be on the court and he just would love to wash his hands of it, he believes that it's his duty to defend the Constitution against populist demagogues who threaten the Constitution. You have to hand it to William Howard Taft.
I was going to remonstrate with you about that quotation on the wall there. It's paired with a rather anodyne one from Webster: one nation, one constitution, one people, or something. How did that get there? Gosh.
I don't know who, even Homer nodded in the creation of the National Constitution Center, and the exhibits folks and I were just talking today, and they said it won't be that hard. If we can't take the quotes off, we can put a lovely plaque over them. So homework assignment for members, we need to come up with at least 2 totemic quotations to replace those at the National Constitution Center. My instinct is what do you think? Okay, here we go. You can be the first one.
I was going to say, even if you could also, in deference to the designers or whatever, whoever's responsible, leave Roosevelt up and put up something sensible to the opposite effect.
Like Taft.
Yeah.
We can have Taft.
Or Madison. Or Madison.
Well, we have to have a Madison.
Yeah.
So do you have a Madison quotation we should put out?
Well, not from memory.
Yeah.
No.
but Federalist 10 wouldn't be a bad place to start.
Yes, of course.
Yeah.
10, 78.
Yeah.
Either.
Hamilton, yeah. So that's your homework. Actually, I'm serious. Write in, email me, or maybe we'll have a contest, and we need to choose quotations from Madison, Hamilton, and others to inspire people about the Constitution.
Well, I have to tell you, when we built the annex to the courthouse in Washington, the federal courthouse, there was a budget line for art in architecture. And there was a committee, and we couldn't agree on any art. So then we said, well, we'll use inscriptions then. And then we couldn't agree on any inscriptions.
Wow.
So there's nothing. We gave $1 million back to the Congress.
Give it to us.
Yeah.
Actually, C-SPAN viewers, a call for quotations. If you had to pick a sentence or two to encapsulate the meaning of the Constitution, what should it be? Write to me, jrosen@constitutioncenter.org, and maybe we'll put it up on the wall of the National Constitution Center.
Okay, the legal principles are clear, but what single ethical principle of Taft's inspires you the most?
Well, he had a noble principle that he introduced in the Solicitor General's office of confessing error. Taft was the US Solicitor General, the government's main lawyer arguing cases before the Supreme Court, and Taft believed that it was so important that the government stand by principle that if it later concluded that it had embraced a position that clashed with the Constitution, it should tell the Supreme Court that it was wrong and withdraw the position. And Solicitor Generals ever since have been inspired by Taft's noble honesty.
So that was an excellent choice. But then following up from the same questioner, and what one ethical principle of Taft's do we most need today? We have that one. So what else do we, and it's by somebody whose name is in part Taft. Perhaps a relation?
Hugh Taft Morales, if you'll allow the shout out. Are you here?
That's
wonderful.
The author of the quotation.
Are you great-grandson? Great-grandson. A round of applause, please, for Hugh Taft Morales. And also head of the Ethical Society here in Philadelphia. I've got some ideas, but what's yours? What ethical principle would you recommend? Honesty.
To a fault. I mean, to lie would, take away the integrity that I think he saw was in his father. It was probably in the framers too. Clarity and honesty.
Can't do better than that. Absolutely. Honesty to a fault. What an inspiring example in a president and Chief Justice.
I must say the book brought out in a way I had never fully appreciated the degree to which Ohio and the Taft family created the Republican Party. It's really remarkable, generation after generation.
On a nonpartisan basis here at the National Constitution Center.
Well, this is related, but different. What practices would Taft recommend in training oneself to be a person of reason?
Intellectual and personal self-discipline, that incredible speech about mastering one's body and spirit and mind in order to be worthy of citizenship in democracy should inspire us all. I mean, think of the personal self-discipline that led this man who struggled with his weight every day to record his precise weight and to lose so much weight because he thought that self-discipline required it. And although he, like me, would wait till the last minute to do his writing, he would stay up late in the White House writing all of his own speeches without law clerks and without speechwriters, poring over the budget numbers and ensuring that citizens understood his positions. He also balanced the budget and turned a budget deficit into a strong budget surplus because of his devotion to fiscal discipline, which he achieved through a combination of lowering the tariffs and raising the corporate tax. That was his other solution for balancing the budget. And then as chief, I mean, think of this. He'd been president and he became Chief Justice and he could have phoned it in, but he gets up early every day. He walks from his home he gives a schedule to his half-brother Charles, and he says, wake at 6, work from 6 till 8, walk to the court from 8 till 9:30, crossing the Taft Bridge, which is now named in his honor, and then walking all the way to Capitol Hill, because that's exercise, hear cases from 10 to noon, lunch, work from noon to 4 and stuff, brief exercise, then more work until dinner, staying up till 10. He says that accounts for 6 hours of sleep, and I don't know where the other half hour went. And he kept up that schedule, every day for nearly 10 years, completely dispelling these allegations of laziness, unfair allegations that dogged him because of his sleep apnea. And it was because of his passion for the country and for the Constitution, and he kept it up until his strength failed and he wasn't able to do it anymore. So that is an inspiring example of intellectual, personal self-discipline that inspires me.
He never rested. I mean, after he left the White House, before he became Chief Justice, he served as president of the American Bar Association, did other things. In a time when it was still possible for a person who had been president to do something useful. I mean, John Adams had returned to the House, which you may not think is all that useful, but it was not simply going off into the sunset the way it seems to be customary now.
He was a founder of the American Law Institute. He was instrumental in founding the U.S. Chamber of Commerce. This was the reason that before he became president, he got this reputation as the super administrator in chief who could solve any problem, including building the Panama Canal. Henry Stimson, who was Secretary of War and State under Presidents Truman, Franklin Roosevelt, Taft, and Hoover, said that of all of those presidents, Taft was the finest administrator of them all. And it's a skill we tend to undervalue. But look at what he created, everything from the modern federal judiciary to the Supreme Court and all these other institutions. It's a rare and underappreciated talent, further vindicating that's the right adjective, the most underappreciated constitutional figure since George Mason.
Well, following up on your reference to the Chamber of Commerce, there's an observation here that Taft was influenced by William Sumner, who taught a view of economics that we would describe as laissez-faire, nearly to like Ayn Rand. What did the founders, Madison and so on, say about too little structure and too much chaos in laissez-faire?
Before the founders, I'll say Taft did study with, if not Sumner's social Darwinist at Yale, who took that position, but at his Yale commencement address, he said society has moved beyond the extreme laissez-faire attitude and now recognizes the need for energetic government to meet the needs of society. So he was neither an extreme libertarian nor anything like a big government progressive. He was a pragmatist who believed in liberty, and that's why he said the goal of government is to be as efficient as possible while meeting the needs of the people and preserving liberty. So that was his view. What were the founders? You can do this better than I, but ranging from the libertarianism of Jefferson to the monarchism of Hamilton to the republicanism of Madison, there was a sophisticated mix among the framers, but none were libertarians in the Sumner sense. And to learn more, go check out this great exhibit downstairs.
I have to catch a train, and this is the last question.
We've delighted the audience long enough too, and I think it's.
How did Taft's life influence the career of his son, Robert Taft, who became senator and majority leader?
What a great note to end on, to pay tribute to Taft's remarkable children. His daughter, Helen Taft, becomes president of Bryn Mawr, an incredibly distinguished scholar of history. Another son is Charlie Taft is Mr. Cincinnati, the repeated governor of Cincinnati. But Robert Taft is Mr. Republican, the most influential senator of the 20th century, who becomes a leader of the isolationist wing of the Republican Party, in contrast to Eisenhower and the more internationalist wing. Taft's greatest legislative achievement is the Taft-Hartley Act, which forbids secondary boycotts, that is, boycotts by against all who do business with a company that's being boycotted in the first instance. And secondary boycotts had been the crusade that William Howard Taft opposed both as a judge and as president and finally as Chief Justice. There's a complete poetic symmetry in the idea that his son forbade them in federal law. But so in that sense, the son was directly inspired by the father, just as William Howard Taft had been inspired by his own father. So the Taft family really has this beautiful legacy of filial piety and also intellectual achievement from father to son to grandson, no doubt to great-grandson. And the overwhelming legacy is that of public service and of devotion to country above party, and another reason to admire the Tafts in these polarized times.
Jeff, it's been a great pleasure to talk to you about the book, almost as great as it was to read the book. So I suggest that you all do that and then tell your friends about it as well. Thanks for writing it.
Thank you so much for coming to NANCC, and thanks to all of you.